I'm Zanelle October, Executive Vice President of ACS, the country's foremost progressive legal network with more than 250 student and lawyer chapters across the nation. Through our diverse nationwide network of progressive lawyers, law students, judges, scholars, advocates, and many others, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and redress the founding failures of our Constitution and the enduring inequities in our laws in pursuit of realized equality. If you haven't already, I encourage you to become a member of ACS. Go to acslaw.org, where you can join and find more information about events like this one. I also encourage you to attend our national convention, which for the first time in ACS history will be held in Atlanta, Georgia from June 6th through the 8th, 2024. As you know, last June, the Supreme Court dealt a serious blow to our country's efforts to close the racial gap with its decision in Students for Fair Admissions. ACS has focused significant energy in the last few months producing podcasts, articles, and events analyzing and helping our members respond to the devastating decision. Last week, ACS President Russ Feingold and I joined a growing coalition of voices calling for an end to legacy preferences in university and law school admissions as one step toward achieving diversity and equity in higher education. Although SFFA only specifically applies to college admissions, the Supreme Court's ruling has had far-reaching ripple effects, further inflaming resistance to diversity, equity, and inclusion in all aspects of American life, including our workplaces. It has emboldened conservative actors to challenge practices and programs that were long considered uncontroversial across corporate America, including at leading law firms. And it has left many employers questioning whether and how their DEI programs are impacted. During this critical time, it is essential that all of us, whether as lawyers, scholars, students, or advocates, remain steadfast in our commitment to diversity, equity, and inclusion. Here to help us understand how we can continue to promote diversity, equity, and inclusion at work in this legal climate is a fantastic group of experts. First, we have our moderator, Kalpana Kotagal, who's Commissioner of the U.S. Equal Employment Opportunity Commission. Also joining us are Corbett Anderson, Chief Deputy Attorney General of the Civil Rights Enforcement Section in the Pennsylvania Office of Attorney General, Marcus Childress, Special Counsel and Co-Chair of the DEI Protection Task Force at Jenner and Block, Jerry Edwards, Staff Attorney at the American Civil Liberties Union of Florida, and Karen Ulrich Stacy, Founder and CEO of Diversity Lab. Thanks to all of you for joining us in this important conversation. With that, I'll turn it over to Commissioner Kotagal to get the discussion started. Thank you.
Thanks, Zanelle, and thanks to ACS for hosting this event and all the other work that you're doing. I've been really lucky to work with ACS in a lot of different capacities. Since I was a law student at the University of Pennsylvania a million years ago and one of the early chapters. And I think the voice you all bring to this work and to all the other aspects of the legal profession is just so important. What a great group we have today, just amazing areas of expertise in this discussion about DEIA issues in the workplace and the impacts of SFFA, whether there is any impact, I think is worth the discussion on the work we do. I want to just start with a few quick housekeeping notes before we begin. As you may have already noticed, today's discussion is being recorded, and the recording will be available live on ACS's website after today's program finishes. If you are interested or in need of CLE credit, there's information in the chat and on the event page on ACS's website that you should make sure you get. You'll need 2 code words to complete your record of attendance for CLE, and I'll be giving those to you today throughout the discussion. Finally, there will be time during today's discussion, I expect, for audience questions. If you want to submit a question, use the Q&A button at the bottom of the Zoom screen. Don't use the chat. We won't be monitoring the chat, and so your question won't make it into the queue. I thought I'd start by some just introductory remarks from my perspective. And obviously, I'm speaking just for myself, not for the commission. Having said that, I think it's important to note that the majority of the EEOC's commission members have expressed strong support for continued DEIA efforts in the workplace in the wake of SFFA. We know what the Supreme Court's decision in SFFA did, and from my perspective, it will undoubtedly hamper efforts by higher education institutions to ensure diverse, equitable, and inclusive student bodies. I think that's problematic. We also know that opponents of DEIA efforts are trying to leverage the Supreme Court's decision to create confusion about the legality of DEIA efforts in other realms, including employment. So today, we're going to talk a little bit about the status of employer DEIA efforts in a post-SFFA world. We got to come up with a new way of talking about that case. I trip over it, I don't know, 3 out of 4 times that I say it, and I don't think I'm alone. I'll just start with very briefly my take on the impact of the court's decision in SFFA. It didn't change the law from the employment perspective. SFFA concerned education, Title VI, and the scope of the Constitution's Equal Protection Clause. It didn't involve employment, and it didn't involve Title VII. Specifically, it didn't address employer efforts to foster diverse and inclusive workforces or to engage the talents of qualified workers regardless of their background. Again, from my perspective, it's really important to remember that DEIA efforts are still important and legal when they're properly implemented. And as important to remember that abandoning DEIA efforts can present its own legal, reputational, and business risks for employers. Okay, I'm done with my initial take. I'm going to stop now and give you your first code word for CLE. Happy spooky season. It's trick. And we're going to get to the meat of the discussion now because we've got such a great group. I thought it might be helpful to start by talking about the business case for DEIA programs. What do they provide for employers? What's important about them? And what's lost if employers turn away from them? Karen, I want to turn to you on this. Throughout your career, you've really focused on efforts to cultivate diversity, equity, and inclusion in the leadership ranks of lots of different kinds of organizations, including law firms. I wonder if you might talk a little bit about the importance of DEIA programs in the workplace and from your perspective, why it's important to retain them.
I'm happy to, thanks. So, Diversity Lab, everything we do is based in data and behavioral science. So I love data. And I could easily spend the next hour just rattling off a bunch of business-related statistics, right? Greater market share, larger financial returns, more innovative and better decisions. Those, of course, all matter. They're all incredibly important to those of you who run businesses, which is all of you. But for most of you, your most important asset is your talent. So that's where I think I would probably focus on as we're talking about this today. If you want to hire, if you want to support, if you want to retain your current talent, you need a diverse workforce and you need a diverse leadership team. There's also a lot of statistics that support this aspect of it, right? That leadership teams, diverse leadership teams that reflect the diversity of your workforce, they make fairer decisions, they make more inclusive and equitable decisions that benefit the entire workforce. There are stats on that, very specific stats, but I prefer to tell a little bit of a story about the early days of Facebook, because I think this illustrates the stats a little bit better than those of you whose eyes will just start to glaze over as I say percentages and correlations and causation and all of those things that I love so dearly. But it's interesting because when you think about having a diverse workforce and the benefits that, and when you think about having a diverse leadership team who reflects and makes decisions that best benefit that entire workforce, there was an early story of Facebook when Sheryl Sandberg was at that point the only female sitting on the board. It was made up mostly of straight, white, non-disabled men. Sheryl was pregnant. And she had put on the board agenda that she wanted to talk about, benefits or leave, those things that, might be important for other women and men in looking at parental responsibilities. And so when it came to that point in the board meeting, everyone was really excited to talk about the subject. They decided first they would brainstorm what they could be doing from a policy and from a benefits perspective for parents, and in particular women, right, who were birthing children, and then parental adoption as well. And they went around the room and they got super excited, and a lot of the men were like, "We know what we're going to do. We're going to have a parking space for pregnant women." And Cheryl was like, "Good, that would be great. I'd love it if I didn't have to walk so far on the Facebook campus. But maybe we could also contemplate 7 weeks of leave, and we could contemplate, birthing support and lactation rooms. And we could even think about these things also applying on adoption." And it changed the discussion from what it would have been without Cheryl in the room as a pregnant woman about to give birth and about to be thinking about what that meant for her life and others at Facebook. And it was the diversity on that board that changed the output, that made it better and more reflective of what the workforce needed than any stats that Cheryl could have given or that I could have given, because I love them so much. So I would say the most important benefit of diversity in your workforce and diversity in your leadership team is your own talent. And it's not just the talent who benefits from that diversity of thinking and that diversity of backgrounds, it's your job seekers too. So there's a lot of studies that show 1 in 3 people will not apply to a company that lacks diversity. So you have your current talent who cares deeply about this, but anybody else that you're recruiting is looking at you through this lens as well. And just said a little bit of a different way, more than 2/3 of job seekers report that a diverse workforce is one of the most important top 3 factors in considering a company to work for. So if you don't have a diverse workforce and a diverse leadership team, you're likely not doing everything possible to keep and to make good decisions for your own talent, but you're also keeping yourself from recruiting really good talent as well. So I'll stop with that because I know there's more that we could say on this topic, but that's what I would at least start with, is think about your own talent.
That's super helpful. Do others want to jump in on this, Corbett or Jerry or Marcus?
I think I'll add a bit. So I think Karen made a good case for the business case for diversity, and I don't disagree with any of that. The hat that I wear and the role that I have is as a law enforcement officer. And just before this panel, I looked at the Pennsylvania Human Relations Act and took a look at the Declaration of Policy in the beginning of the act. And in addition to companies, employers being as successful as possible, I think that's important. From a government's perspective, non-discrimination is important to the health and fabric of our very society. And it talks about non-discrimination being important to prevent domestic strife. It talks about discrimination undermining the foundations of a free democratic state. And there are a lot of examples throughout history, deep American history, more recent American history, in between, where we've seen that play out. So I would just echo what Karen said about the business case, but also mention that it's important for employers as members of a free and democratic state to do what's right.
Thanks for weighing in on that. I think there are so many examples in the world today of why our commitment to those values couldn't be more important, and the role in which diversity, equity, and inclusion plays in fostering that, I think is vital. I'm glad you brought it up. I want to pivot here directly to SFFA and the challenge to diversity, equity, inclusion, and accessibility programs in the workplace. They preceded SFFA too, but have obviously grown in volume, in number since then. And I think it's pretty clear that there are lots of groups that oppose diversity initiatives in the workplace, and some of them have been active since the Supreme Court's decision in SFFA bringing lawsuits to end the use of a variety of different DEIA programs in the workplace. Marcus, you've been working with your clients to defend their DEIA programs and evaluate their DEIA programs, and to adjust programs proactively to address the potential for legal risk. I wonder if you could talk us through some of the different categories of challenges that you've seen. As we've been going back and forth in preparation for this discussion, we've been talking about different buckets or different categories, and it would be great if you could sort of talk us through what some of those categories are and how you see them showing up.
Of course, thank you. Look, I've broken them down, and this you can sub-parse them if you want, but really into 4 categories or 4 buckets. And the way I think of it is business operations is the first bucket. Then your kind of traditional reverse discrimination claims under Title VII, the classic employment type challenges, board diversity, right? We've seen people challenging board diversity, and then shareholder action, which is very broad, and I'll touch on that kind of at the end, but I'll go through them one by one. But before I go into the actual buckets, something we're also seeing that I think people are always wondering is how are people able to afford so many claims? And what we're seeing is that you're immediately seeing plaintiffs file for preliminary injunction so that you can immediately go up on appeal if there's an adverse ruling against you. So we're not really getting into discovery or motions for summary judgment on most of these cases. And it's actually a relatively inexpensive endeavor for a lot of these plaintiffs who are almost cutting and pasting a lot of these claims and just putting in new facts for them, depending on the bucket. But I'll start with business operations. And when I think of business operations, I'm thinking of programs to diversify your supplier vendors or accelerator programs, things that help the business itself identify ways to diversify its vendors or the folks that they're doing business with. And with these programs, we're seeing a lot of challenges on, and you're going to see a theme here, under 1981, right? Or various state laws like the California Civil Rights Act. And I have to say, I think I'd be remiss if I didn't say that it is particularly annoying whenever you see folks citing 1981 or state civil rights laws, because we know that's not what these laws were enacted to protect, right? So I think that has to be set up front, but these are the laws that are being cited. In response, a lot of times what I think our go-to is to challenge the standing, the plaintiff's standing. And I think we were fairly successful early on, right after SFFA, challenging on standing. But these plaintiffs are becoming a little bit more sophisticated and amending their complaints in a way now where the standing issue is not so clear and is not, it would force more litigation, more expense on our clients. And so, look, that's kind of the business operation side of the house. Another way of business operation, another, I guess, subcategory of it will be like investment funds, where funds are looking for minority-owned businesses or endeavors to invest their money in. Of course, I forgot to say when it comes to 1981, it deals with a contractual relationship, right? So prohibiting discrimination and contracting. And when it comes to investment specifically, right, it goes towards 1981's guarantee of race neutrality in making contracts. But with investments, that brings in a separate issue of First Amendment issues that are still actually being litigated as we speak, and really goes to freedoms around who companies or individuals even choose to even enter into contractual arrangements with. And the last subcategory, which I think you've probably seen, a lot of us are lawyers, if not all of us on this call, will be with like the fellowship programs with companies or law firms. Again, this is still a gray area where, look, some would argue it's not a contract. Others might argue it is a contract or form of employment. But this is where we're seeing challenges as well under like the business operations side. I promise the last 3 buckets are much quicker. I promise.
No, I suspect that folks on this call are taking notes about these buckets. So I think you should take your time and work through them.
Okay. The next bucket is a classic reverse discrimination type claims. Before when I look, I have to give you all a caveat. Look, I am a congressional white collar investigator who does a lot of litigation as well, and that's why I'm learning this area as well. Particularly the discrimination claims. When I used to read these, you would see Fisher cited, right? And Fisher maintain the status quo of affirmative action in race-conscious admissions and education. So going back to Commissioner Kotagal's point, right? It has nothing to do with businesses, but it's being cited in this context. Now you're starting to see claimants cite SFFA and some of the dicta in that opinion to make challenges when a company, for example, makes an open pledge to have a certain diversity level in its leadership ranks. I think it's particularly problematic when these goals are tied to compensation for executives. I think that's where you're seeing these plaintiffs really target certain companies. And with this bucket, it's traditional Title VII claims, right, alleging race-based employment decisions. But again, I think it's worth highlighting that a lot of times it's when it's tied to compensation with reaching these goals or quotas or like very specific numbers of what a company or organization wants to reach with this racial diversity. The third bucket is board diversity requirements. And the main reason why we even talk about board diversity requirements is to explain that states are also having to respond to challenges after SFFA. Let's take, for example, some states may have requirements that require racial, ethnic, or sexual orientation diversity requirements on boards of public corporations that are located in that state. They're having now to fight these types of claims. And I think it is particularly interesting that the claims based on gender have been dismissed, but the claims based on race have survived and now are reaching the summary judgment stages or even on appeal, right? So now it's singularly focused on the race-based challenges, which kind of tells you how gray the area, or at least the judge or the courts are interpreting this area of law when it comes to board diversity requirements. And then the fourth bucket and the final bucket, and then I'll stop talking, is
No, I have follow-up questions for you, so you're not done yet.
Oh no, I hope can step in and help me out. But shareholder actions, and this is actually where I spend a lot of my time, is on the shareholder actions. So same kind of fact patterns where companies are committed to more diverse workforces and having actual numbers, and plaintiff shareholders are challenging on similar grounds, whether it be Title VII or 1981 or various state civil rights laws. And these have largely been dismissed by the court, saying that these are matters of public policy and not for the courts to even decide. Where I think there has been much more action, and I'm going to just be blunt here, is where companies took action post George Floyd in the name of what I will say civil rights assessments. And they received very specific recommendations to implement very certain remedial efforts that I think are actually noteworthy and should be done. And now you're seeing post SFFA other shareholders bringing proposals to review the requirements or recommendations from these civil rights audits now in light of SFFA. Mm-hmm. I think it's putting companies in a little bit of a bind of what do we do here? Are the recommendations that we previously received from probably a very powerful subset of shareholders now legal? And then how do we respond to these new proposals and challenges? And this is where it really gets into the reputational risk for companies and how are they messaging their DEI, which goes to the point of, right, this being a business endeavor and good for business. And is it going to attract scrutiny from AG's offices like Mr. Anderson here, or from congressional offices and things of that nature? And so I went through the 4 buckets of litigation, but I think behind that is always the reputational, whether it be external or preserving and keeping your own internal talent or attracting new talent, or the reputational risk of attracting political kind of scrutiny like we've seen in the Dobbs context that can really put companies in unfamiliar ground and footing.
Thanks. I think one question came in through the chat that I want to make sure I put to you immediately, which is, in the 1981 space, are there cases that you would encourage folks to follow closely? I mean, there's obviously, I think there's the Fearless Fund case, right, which we all are tracking. I wonder if there are any others that you think it's important for folks who are interested in this space to be paying close attention to.
So Fearless Fund, I think, is the one that we all have our eyes on. To be completely candid, a lot of companies and firms are now modifying their programs, especially in the reverse discrimination or business operations realm, because I think companies and law firms are realizing they can achieve what they're trying to achieve without necessarily requiring that it be a historically underrepresented minority group, for example, in like the express language of a program. And so the Fearless Fund case, although I think it's really going to come down to First Amendment type issues, will maybe have some good insight into at least how the 11th Circuit views the contractual relationship between these types of programs. But that's the one I think that I'm at least particularly really tracking. Yeah, I think that's the only one right now. Everyone else is kind of adjusting programs to moot these claims out.
And then let me add one more follow-up question. Karen, this might actually be best directed to you, but whoever wants to weigh in on this, where we're dealing with goals, with flexible goals, with goals that don't operate as quotas, which we all acknowledge are problematic. How should we be thinking about goals? And in particular, because I think that's a really important issue. And also, Marcus talked about goals that deal specifically with racial demographics and breakdowns. And I wonder whether we're also seeing concerns about goals that sweep more broadly across historically underrepresented groups or protected groups. I don't know, Karen or Marcus or really anybody else who might want to speak to that.
Yeah, Marcus, if it's okay with you, I'll weigh in first and then you can check me on the law. So as Marcus knows, because Gender and Block is one of our favorite firms because they do a lot of work with us at Diversity Lab, goals are not illegal. And setting goals, like saying, for instance, that you want your leadership diversity to be reflective of your workforce diversity, for instance, is not illegal. Now, if you make hiring decisions on that, or you do something from a decision standpoint to set aside, create a zero sum, or a quota, truly a quota, then yeah, you're running into legal territory. But I think the problem that people forget about goals is that when we think about anything else we care about in a business sense, profitability, marketing, tech, we set goals, right? Because the company's trying to be profitable and you don't just put your hands up and say, well, let's see what happens with our profitability. You typically say, gosh, we'd really like to be here. And you set a percentage or you say why as the number. So that's okay to do with creating an inclusive and equitable environment as well. Gender and Block does the Mansfield rule. Consider 30% underrepresented humans every time you have an open leadership position. It's inclusive, right? It's adding more humans to the consideration bucket. It's not asking you to make a decision based on that 30%. It's asking you to open the door wider. So that's what I would add on the goals front, is that people shouldn't shy away from it. And they should be thinking about goals in the same way they think about other business priorities.
I agree with all of that. And I think when we're advising clients, have actually used the exact same language of inclusivity. And that's how you message it to your external stakeholders, is this is an inclusive program. And we always, and this is probably because of the clients we serve, we do tie it back to a business strategy and a business goal, because we all on this call probably all believe that a diverse workforce is a better business product for our clients. And I just want to go back though and highlight the one thing though where I do have, and I know Corbett's probably going to get into this shortly, but what I do get a red flag on is when I see compensation tied goals, right? And I'll just throw 30% Black and Hispanic executives within the next 5 years. And if you reach that goal, you get an X bonus, right? That is where a red flag goes up. And it might sound like an extreme example, but there are some cases out there from the last couple of years that have these very similar type fact patterns. And so I would just be careful in that type of goal setting, not to tie it to compensation, not to put it in your annual reports, things of that nature, and keep it really inclusive and more aspirational to drive the culture of your business rather than specific to compensation.
Let's turn, I think this is a perfect segue into the kinds of things that Corbett is going to talk about. And then we have a good question from the audience that I'll bring back into the conversation in a minute. We've obviously talked about the challenges that are out there, and Marcus, thanks for breaking those down into the buckets. Wait, let me ask one more question before I turn to Corbett, which is, where do we think the challenges to DEIA related trainings fit? Do those fit into the business operations bucket? I think that's probably where they go.
Probably where they go as well.
Yeah.
Look, I think you can, I'm sure there's been some novel creative arguments that maybe if an individual is let go, they might cite back to some type of DEI training in the reverse discrimination world, right? But I think it's mostly going to be in that business operations bucket.
Perfect. Okay, Corbett, now to you. What can employers do? Right? We've started into this conversation about goal setting as one example of things that employers can engage in and how they can engage in it in a way that's okay. I think what can employers do? What must employers do to comply with Title VII? You've been wrestling with these issues, Corbett, in both federal and state government, and whoever's managing the Zoom, could you pin Corbett and unpin Marcus and Karen? I don't know who's manipulating that, but I'm sure somebody will take care of it in a minute. There we go. Perfect. I know, Corbett, that you've been wrestling with these issues for a long time in both federal government and state government. A former EEOC litigator right here, which I always love to see. What would you tell somebody who was worried about the relevant legal boundaries in this area? What kind of practices are clearly okay? Marcus just took us into some examples of practices that might raise flags. What other kinds of practices are you thinking about that pose a little more risk? What are clearly not okay? Would love to get your thoughts on what employers can and should be doing in this space.
Sure. I think the top line message that I would give to an employer that is worried is to keep going or start, and really above that is be proactive. You know, some of the history that I mentioned earlier and the problems we're trying to address, you know, are deep, and there's a gravitational pull toward them. So we need to be proactive to counteract it. So be proactive, but be thoughtful and do things in a way that is legal. That means, you know, keeping an eye on what those legal boundaries are. Within that context, there's a lot that employers can do. So being proactive means having a strong EEO policy that's embraced by the management of the company or the organization. DEI and EEO training is, you know, not just legal, it's recommended. It's something that should be done. It has to be thoughtful and respectful of everyone, but it should be done. I would say robust analyses, self-analyses of your selection procedures, your recruitment processes, your employment rates, your workforce demographics versus availability of the qualified labor pool. That should be done.
Your compensation.
Sorry?
Compensation is another area you should be auditing.
Exactly. Auditing your compensation practices. All of that should be done because that's part of being thoughtful and then being able to act on whatever you find. I think that another thing that can be done that is, you know, companies, organizations have a clear green light to do would be to remove unnecessary barriers to EEO that, you know, aren't necessary. I'd note that here in my state, in Pennsylvania, our governor, one of the first things he did was remove the college degree requirement for most state jobs. And that's something that's race neutral. To my understanding, it wasn't race conscious, but it has the added benefit of promoting equal employment opportunity, right? So that's an example. If a company looks at or organization looks at its workforce or its applicant flow and realizes it's not getting the type of candidates that its competitors are or that are available, it can mix up its recruitment and selection and sourcing practices to gather and draw a more diverse talent pool. Those are all things that can be done and should be done, in my view, to promote equal employment opportunity and diversity, equity, and inclusion. In terms of the boundaries, where things get trickier is when an organization is making race-based decisions. And by and large, that's not legal, right? There are circumstances, however, where the Supreme Court has made clear that it is legal. And if an organization finds itself in a position where those factual circumstances are present, I would advise them to seek legal counsel to make sure that they're present and then to navigate to the point where decisions can be made. In terms of what the absolute don't do's are, you mentioned them already. You know, quotas, set-asides, particularly voluntary ones, there are certain circumstances where quotas might be necessary in the context of a remediation of actual discrimination through a court order or EEOC conciliation agreement or what have you. But assuming we're talking about something that's voluntary, a quota or set aside is generally not going to be something that will pass muster in the courts. I would also say that if there is a complaint of discrimination and you and a company were to investigate and find that discrimination was actually present, or if in one of the routine audits that the company does of its employment practices or its compensation practices, it finds discrimination, that can be remediated. And that can be remediated in a race-based way because you're remediating discrimination, right? And that's something that even the Supreme Court said in SFFA is legal. If an organization, particularly private sector organizations, I put a pin in it for organizations that are covered by the Constitution. If an organization were to determine that there's a manifest imbalance in a traditionally segregated job category, that's a situation where the Supreme Court has said a company can take race-based action to solve that problem. But the organization has to do so in a way that is respectful of third-party rights, that isn't designed to engage in just naked racial balancing, that's not designed to maintain any sort of racial or ethnic mix, but to attain something. And what it's attaining, what the organization is attaining, has to connect to some sort of availability deficiency. If those things are true, the Supreme Court has said that that's likely going to be legal.
And that's a very narrow set of circumstances, but a really important one to remind folks that remains out there.
I think it's it's very important. And I think that it's something that could be employed more often by companies that are serious and want to take more serious measures, again, with the assistance of legal counsel. And you know this, I'm sure, but I would point out that the EEOC has affirmative action guidelines that point out that if an organization were to conduct an analysis and have a reasonable basis for doing so, a lot of these affirmative action, EEO, DEI methodologies that we're talking about could be defended successfully, but simply by pointing to the organization's good faith reliance on those guidelines. And I think that that's a strategy that might be employed in the future as well. So I'll stop there.
It's super important. And I think it really underscores, a couple of the points that both Marcus and Karen have made about the importance of data and the connective tissue that binds DEIA programs in sort of our modern parlance with long-term efforts by thoughtful employers to ensure that they're not utilizing policies and practices that give rise to a disparate impact, right? I mean, we're in this space between both of those things. And I think your comments really help to connect those pieces. I wonder if anybody else, Marcus or Jerry or Karen, want to jump in on Corbett's remarks. Otherwise, I'm going to pivot to the front lines of Florida and Jerry's work there. Okay, here we go. Oh, wait, before we do that, let me just throw a question from the audience out to you all. A very sort of thoughtful question about whether when companies that are being targeted by the litigation make changes to their programs that are being attacked in order to moot cases, does it embolden, I think is the word that the audience member used, does it embolden more aggressive such challenges to other programs, by other employers? What are folks' thoughts on that? Marcus, maybe I'll.
So this is a question that I have given a lot of thought to in my personal as well as legal capacity, and I have two kind of responses from just like advising clients. One is, litigation can be such a drain on doing the actual work. And I think we can't lose sight of how important this work is and how much being involved in litigation can drain efforts to continue the good work in this space. And then the second piece of it is, I think we have to be realistic about the appellate courts in our country right now. And I think I'm starting, and I welcome all opposing and views on this. I am more of the trench warfare, let's not create more bad law method. I'm really nervous of the law continuing on this slope of where it could possibly go. And so by mooting these claims, I think it eliminates the potential of the law. Let's just say, look, there's no stare decisis right now, right? And so I'm just nervous about the law going even further than where it is right now. And mooting it allows the work to continue and also preserves where we are legally right now. That is a very personal view, and I would love to hear how others feel about it.
It's super insightful and very pragmatic. I wonder if anybody else wants to jump in on that question as well before I turn to Jerry. Okay, go ahead, Corbett.
Yeah, I would echo what Marcus said about knowing where that boundary is and where the line is, and taking a step back behind that line and being ostentatious about how you're doing so. Because I think it's important that, set-asides, quotas, those types of things, those are illegal. And to the extent a company and organization's actions or its statements suggest that it's crossing that line, it undermines the entire enterprise and it invites litigation, even if in actuality, the organization is not setting up a quota or a set-aside. So I think it's really important to support the good programs by being very clear about what an organization is not doing. And I think that helps to save the entire process.
Yeah, really, really thoughtful. And I think creates an intersection with companies or employers' marketing and PR work to tell the story about the work they're doing and how they're doing it and the data they're relying upon. Okay, looking at the flip side of these issues a little bit, we've seen so many states recently passing laws limiting what can be included in DEI trainings. Just focus on that bucket for a minute. And Florida really is the front lines of these issues. I've said that a couple times, Jerry. It would be really helpful if you could speak to some of the restrictions that you all have seen in Florida and what arguments employers who are working to protect their DEIA efforts are using to respond to or rebut such restrictions. And anyway, I'll let you talk. There's plenty to say on that from the work that you're engaged in.
Sure, I appreciate the great questions here. So in Florida, as in many other states, we have seen aggressive efforts to crack down on ideas that the current people in charge in the state disagree with. And a lot of this flows from Trump's executive order 13950, which prohibited federal contractors, federal agencies, and others from instructing on divisive concepts. And so in these bills, a lot of what you see are these same divisive concepts or similar divisive concepts being taken from that executive order and almost put verbatim in bills like the Stop Woke Act, or in similar bills we've seen in other states like Tennessee, North Dakota, and I'm sure there's quite a few other, Texas. But so in Florida specifically with the Stop Woke Act, and that's the first law I'll talk about, and also kind of briefly address SB 266, a recent law that just passed here in Florida. You've seen the state kind of target two different groups, and there's some inner overlap between the two. So we see private businesses being targeted for mandatory trainings that teach these divisive concepts. And to kind of just talk about what these divisive concepts are quickly, I mean, they're things like unconscious bias, white privilege, systemic racism, affirmative action, diversity, equity, inclusion itself. And so you have these concepts that say something akin to, you can't talk about, or they're a little bit savvier than that. What they say is you can't promote the idea that people should not be treated without respect to race, or that people should receive adverse treatment to promote diversity, equity, and inclusion, but you can talk about these ideas objectively as long as you don't endorse them. And of course, it's very unclear exactly what it means to talk about something in an objective manner without endorsing it. And so that's kind of their little trick here. But the Stop Woke Act has these divisive concepts, and they targeted private businesses, mandatory trainings, and they also targeted universities, classroom instruction and trainings at universities. And so there were 2 lawsuits brought, one on behalf of private businesses and one on behalf of professors and students. We litigated the professors and students, and our colleagues at Protect Democracy litigated the lawsuit on private businesses. And so additionally, in addition to us on the university and students, we also have LDF, our national branch of ACLU, and Ballard Spahr, the law firm. So we do have injunctions against both these laws. And recently, the 11th Circuit heard arguments in the Honey Fund case in the private businesses. And the good news is that it looks like they're going to, based off of reading the tea leaves at oral arguments, which may or may not be accurate, they're going to uphold the First Amendment claims in those cases. And so that's really good news. And I guess I can jump quickly into the First Amendment claims and explain those, and then maybe circle back to 266, which talks about how it overlaps with education. And so the First Amendment claims here are basically viewpoint discrimination claims. And for those of you who aren't First Amendment attorneys or litigators, in the First Amendment sphere, viewpoint discrimination is the worst thing you can do. It's presumptively unconstitutional, and there are very few exceptions to it not being unconstitutional. Basically, it's almost never constitutional. Just to give an idea of what viewpoint discrimination means, it means you can talk about one side of the argument, but you can't talk about the other. So let's say I think apples are the best fruit, somebody thinks oranges are the best fruit. I pass a law saying you can only advocate for apples being the best fruit. That's viewpoint discrimination. This law is, the Stop Woke Act is viewpoint discrimination because it prohibits advancing these concepts, but it doesn't prohibit disagreeing with them. And so the state's main arguments against it were that if you strike down the Stop Woke Act, it's an anti-discrimination law. You are putting in jeopardy every anti-discrimination law out there, including the Civil Rights Act of 1964. And what the court basically said is, no, what you're targeting here is pure speech, not conduct, and not speech incidental to conduct. And so the only way you can tell if somebody violates this law is by looking at their communication, by looking at what they're saying. And so are you expressing this prohibited idea? Whereas conduct would be something like hiring, firing, promotions. And speech incidental of conduct would be something akin to refusal to serve, putting a sign up that says no people of color at this restaurant. I mean, that is speech, but what they're really prohibiting there is the conduct itself of refusing to serve people of color. And so in evaluating these arguments, the district court rejected them, issued an injunction against the law. And I do think the 11th Circuit is going to uphold that injunction and rule that it is a violation of the First Amendment. Now, there are some other claims you could pursue. I won't go too deeply into those. Vagueness is a great claim. And then also we've brought an intentional discrimination claim, racially discriminatory purpose, for a race neutral law that we think was enacted to discriminate against Black professors and students, but that's a little bit afield. So, but one other important concept I think I should cover too is government speech, just because that plays such a big role in the educational context and where government employers are carrying out trainings. And so what government speech basically means is when the government speaks, there is no First Amendment protection. The government can say what it wants, and the only recourse there is a democratic process. And so when something is government speech, it means that a court is going to let the government do what it wants. And in the case of government trainings, say a government employer is doing a DEI training and the state passed a law saying no government employer can do a DEI training, under the First Amendment, generally, that's going to be government speech. There is some trickiness when it goes into the educational context, the university level, because of academic freedom. And really what academic freedom protects is professors' ability to engage in classroom instruction and in research. And so if that were to restrict their ability to engage in classroom instruction or research, it could run afoul of the First Amendment. But that's very much an exceptional situation and a carve-out from government speech from the case Garcetti. But generally, that means there's no First Amendment claim. That doesn't mean there's no constitutional claim. You could bring a vagueness claim under the Due Process Clause saying that the law is unclear, and you don't know what it prohibits, and so the court should strike it down because you could get in trouble without really knowing you were violating the law. And we've seen those arguments be successful. They were successful in getting this Trump EO struck down. Additionally, I will now kind of circle back quickly just to SB 266. This is a law in the educational context where the state just banned all DEI funding for higher universities, for programs and activities. They did a very small carve out for student groups, but we've even seen student groups being denied funding recently based off of advocating for diversity, equity, inclusion. It was a LGBTQ plus group that was denied funding to participate in a pride parade when in past years they had been granted that funding. So it's a very significant, unfortunate law. We have not litigated anything with it yet. There is currently an ongoing lawsuit that just had a hearing on the preliminary injunction. We are also investigating and evaluating our litigation options. So those are the two big laws in Florida right now. There are a lot around the country. The ones around the country have mostly focused on universities and the educational context.
Thanks for that. And for the constitutional primer, for those of us who are not First Amendment lawyers, I feel like it provides such an important tool in the work that we're all engaged in. I'm also struck as I think about Florida, about the teachers in schools and the professors, who are being forced to teach the idea that this was in the press some number of months ago, right? That slavery had some benefits for Black folks, right? I mean, I think the interface or thinking about places of education as workplaces takes us into, yet another set of complexities around the impact of these policies and candidly their legality. We're getting really, I don't know if anybody else on the panel wants to jump in on any of those issues in Florida. Jerry, thank you. Super insightful. And thanks for the work that you all are doing. I have an interesting question. And folks, I'll just say, whoever's out there and listening, this would be a good time to put questions into that Q&A box. I have an interesting one here for the group about sort of a predictive question about whether folks think that the Supreme Court's analysis in Students for Fair Admissions will get carried over into the Title VII space. And specifically, the court was obviously, the person sort of taking the position that the court was looking for universities to provide robust evidence in support of their policies or practices. I think, for those who have been following along and look at the district court record, there does seem to, in fact, be that evidence in the record, but it was overlooked by the Supreme Court, and it's in consideration. The question is, what kinds of evidence, and I think some folks have brought these examples out, but what kinds of evidence should employers be marshaling to defend their DEIA programs, policies, practices? And Karen, I think you are the data guru on this panel, so maybe I'll throw that to you.
Yeah, and I'd love Corbett and Marcus and Jerry and others to weigh in. I will say two things on this front. Look for the cases that have been thrown out and or won, because there's a lot of clickbait stories on the stuff that's going into court, but there's not a lot of stories on the stuff that either gets dismissed before it sees the light of day or that gets dismissed in court. And the Starbucks derivative shareholder suit is a good example, right? I clocked 89 stories on the Starbucks suit. I clocked 2 on the dismissal.
That's right.
And so look at those fighting back, look at those cases that are getting dismissed, because I think that's some of your best evidence to marshal, but I'll let others weigh in.
I think that's so good. And before anybody else weighs in, I'll just throw out the second CLE word, which folks may have figured out. It's treat. Happy Halloween. The Starbucks opinion is, I think, really worth reading. And in particular, sort of the back half of it, or the back paragraph that talks about how this really was a political effort by certain shareholders, as opposed to really being grounded in business practices. And I think Karen's right. Look at the cases that have been thrown out and the practices that are being utilized in those cases and the data that those folks are relying on. I think it speaks, I'll just say here and then open it up. I think it really speaks to the importance of undertaking that analysis. Now is a really good time if you're an employer to be looking at your DEIA policies and practices. What are you doing? Why are you doing what you're doing? How can you support and justify what you're doing? If you're not already undertaking that kind of self-analysis, as several members of this panel have suggested that you do, you should do that. What else? We have about 3 minutes, I think, before all of us turn into pumpkins to continue the Halloween analogy. Are there any other questions from the audience, or do any others on the panel want to weigh in with any last thoughts before we say goodbye?
I just wanted to go off what you just said about the proactive assessment of your programs. That's the one thing I think I don't know if I can drive home enough. And I think it allows you to take a very thoughtful, deliberate approach to your programs rather than when you're in the reactive responding to litigation track, where maybe when you're having those discussions, some internal stakeholders may not be willing to engage in the true conversation of their culture because you're dealing with an active litigation. And the second part of that is and I think we think a lot of this through the legal lens, is looking at, and with the touch on the communications and advertisement of your programs and making sure they all align, making sure your executives have standard talking points so that if they're on Squawk Box and they get asked about DEI, right, they know exactly how to describe their program in a way that doesn't invite litigation. All of that should be part of the proactive process rather than the reactive process. And it's not that hard to get aligned. It just takes deliberate intentionality to do so. And doing it with the legal department allows you to have these candid conversations in a privileged manner rather than one that can later be disclosed during discovery in a way. So that's why I think this is truly a legal analysis post SFFA that allows you to have these protected communications.
And undertake the analysis with counsel's involvement. Yeah,
it's a legal, exactly. A legal analysis of your program.
Okay, I think there's one last question and then I'll let folks go. Corbett, did you want to weigh in before I close this out?
Well, I would echo what Marcus just said and what Karen said. And I'd also point out to the last question, if an organization is pointing to sort of societal historical discrimination that's unconnected to the actual organization's history, that's not likely to fly in the Supreme Court's eyes. And I'd also, if because SFFA was a diversity case where the rationale for the decisions was diversity and educational benefits that flow from it, we know what they think about that. And to go back to Karen's first point about the business case for diversity, to the extent an organization is supporting its affirmative action, its DEI, whatever decision is being challenged by diversity in and of itself without connecting it to an analysis, then that could be subject to some scrutiny.
Thanks for that. And thanks to this great group of experts and to ACS for hosting this. I really appreciate it. There was a question about whether the EEOC will be putting out guidance on these issues in the wake of SFFA. As I said at the top, there is a pretty clear indication from a majority of commissioners who believe that DEIA programs, when carefully and thoughtfully implemented in the workplace, remain legal after SFFA. I suspect you'll be hearing from all of us more substantively in the weeks to come on these issues and the months to come on these issues. And I look forward to continuing the conversation with those of you who are engaged in this work. ACS, thanks for hosting. Everybody, thanks for joining. And I hope folks have a great afternoon.